Okay, in this video we're going to go over the real estate purchase contract, which is included in this program. It is several pages, and I'll go over the blanks. Most of them are pretty simple. There's a few regarding the numbers, which I'll explain on the board. And you can use this as a purchaser, whether you're an individual or whether you're a company, LLC, corporation, whatever. Most of the disclosures that are required by state law are required by the seller. So this may not have those disclosures required by your state, but you don't really care. You're the buyer. The disclosures are for your benefit. There's very few states that have disclosures that are in favor of the seller that the buyer must make. So this should be satisfactory in all 50 states. If you feel that you'd rather use your state contract that the real estate brokers or agents use, or if you are one and you feel like you have to use the approved contract, I also have an addendum to that you can attach on any standard realtor contract, and it has the same basic information. Okay, so here it goes. At the top here, we have this purchase agreement dated this blank day of blank. Obviously, that's the date you're signing it. By seller, whose address is, and by buyer, who's your company name, whose address is. Now, this contract is assignable. And the reason it's assignable is because it doesn't say it's not. If a contract doesn't say it's not assignable, it is assignable. Even, you don't have to put and or assigns, by the way. That doesn't mean anything. If the contract doesn't say it's not assignable, then it is assignable. So you could always put it in one entity and decide either to wholesale it to somebody else or to put it in a different entity. So don't get bent out of shape if you're not sure which entity to put it in as buyer. Okay. Paragraph 1, the property. So you put the county, state, and legal description. Now the best way to get the legal description is if you have a copy of the mortgage or deed of trust or the actual deed to the property. It'll usually say something like Lot 1, Block 2, Shady Acres subdivision, second filing, and something like that. In some states, it's a meets and bounds description, which is which goes northeast this way, southwest this way. That's a much more complex description. Do you have to have it if you don't know it? The answer is no. The title company can always fill that in later. But if you have it handy, wouldn't be a bad idea to put it in there. Okay, so paragraph 2, the property is transferred subject to the following liens or encumbrances. Lien is an encumbrance. So you list Bank of America loan number 20124 in the amount of X, or by mortgage recorded at a certain date or dated a certain date. Just as much description as you can to describe the liens that you're taking subject to. Okay. It also says, by the way, at the bottom there, that they'll sign a limited power of attorney to you at closing. So we talked about the limited power of attorney. On page 2, this is where people get a little confused. The purchase price and earnest money and the terms and so forth of the numbers. So basically the purchase price, fill that in last. This is what we'll do. First, fill in where it says credit for taking property subject to. So let's say you're taking subject to a $92,000 loan, okay? And then you're going to give the seller, let's say, $5,000 at closing. So you're going to give them $1,000 earnest money now, okay? And that means, and then we have a loan payoff. Now, a loan payoff would be if they had a first and a second, and you were going to pay off the second and keep the first at closing, which is not that common, but if it is, you would put that here. Otherwise, you'd leave that blank. The cure amount. Now, let's say that it requires $3,000 to cure it. So let's say we'll put $3,000 in this blank right there. Seller financing. If the seller has a lot of equity and you're going to give them a note for the difference, you would put that there, but that's pretty rarely the case. So in most cases, the loan payoff of a second or seller financing will be blank, but they're there just in case you need it. So we agreed we're going to give the seller $5,000 at closing. We gave him $1,000 now. We got to come up with another 4 plus the 3 for the cure amount. So what is due at closing? $7,000. So if you took it all together, the 92 plus the 3, okay, plus the 5 that you're paying him total, the purchase price is $100,000. So just do it backwards, because you're giving a total of 5 at closing, $1,000 earnest money plus the 4 at closing, the $3,000 to cure it, and subject to $92,000. So the 92 plus 3 is 95, the $5,000 to the seller, but you're coming to closing actually with $7,000 because of the 3, and then you gave $1,000 as earnest money. So I hope that makes sense. And this is your basis in the property, what you paid for it, $100,000 for the property. Okay. It says to be paid in escrow with escrow agent, and I recommend you pick the title company or escrow agent to hold the escrow rather than the seller. Even though it's customary for the seller to pick the title company, I recommend you pick one in case their title company turns out to be a bunch of dopies who don't want to do a subject to. You'll notice here it says credit for taking property subject to existing loans, and the little 2 stars, and then below it said, it basically says, it's a long paragraph, I'm not going to read it, but it basically says, let's say we come in and it's not 92 when we go to verify it, it's 90, so it's 2,000 less. So what this agreement says, you're not paying them 2,000 more in cash, we're just going to reduce the total purchase price, so you're not coming out of pocket with any more money. Does that make sense? But in the opposite, if it turns out to be not 92 but 93, then the amount of cash, the $5,000, is reduced by $1,000. All right, so it works in your favor either way if that balance that they're giving you is not correct. Okay. Number 4 is about inspection and marketable title, and paragraph 4C on the next page says the seller agrees to convey the property by warranty deed subject to the following liens, and then you list again what liens are going to remain there. So if there was a first and a second, you listed them earlier, but you paid off one of them, and at closing you're only taking subject to the one. If you're taking subject to the 2 loans, then you put those 2 right there. Okay. Number 5, earnest money. Again, you're going to put that earnest money in the blank there. Number 6, closing. Notice how it says on or about. Most contracts say on or before. On or about doesn't mean on or before. It means on or about this date plus or minus maybe a week or so. So it can buy you more time if you need it. Okay. Number 7, the seller has no rights to the property after closing. We're making that very clear because I've actually had cases where clients had bought a property subject to, and then they got a letter from an attorney a year later saying, that's not your property, give it back to my client. No, 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 no. Once he deeds it over, it's no longer his, and this is his acknowledgement that he has no rights to the property. Paragraph 8, they agree to provide you access to the property. You need to show it to contractors or prospective tenants. Number 9, it says not only does it say doesn't it prohibit you from assigning, but it specifically says you can assign it. And if you do assign it and that person doesn't pay, then you're not liable. Because normally when you assign a contract, you don't assign away you sign away your rights but not your obligations. This says if you assign it to a third party and they don't object to it within 48 hours, then and you give them notice that you've done it, then they're going to agree to waive any liability against you if that party you assigned it to doesn't perform. Number 10, the due on sale disclosure. And that basically discloses there's a due on sale and that they may call it the loan due, et cetera, et cetera, et cetera. And then paragraph 11 is just a bunch of individual acknowledgments that you want them to initial. Some of them are so blatantly obvious, but you never know when someone's going to come back and argue. So have them initial each one very carefully. And then number H under that, 11H, seller understands she may be selling the property for less than its full market value and has chosen to do so because circumstances dictate that immediate sale, even at a discounted price, is in the seller's best interest. These reasons include, but are not limited to, and then have the seller write it in. I have a divorce, I need to move, I can't afford to make the payments. That way it's almost impossible for someone to come back later and say you took advantage, you stole the house, you stripped the equity. Because they wrote it in there. They wrote the reason. That's really, really powerful. Number 12, entire agreement, governing law. Number 13, you put in estate. Number 14, severability. And then signatures on the last page. There is a place for a notary's acknowledgement. It's not essential, but I recommend you do it because then you have a third-party witness who can come back later and say, yeah, they weren't drunk or crazy or they didn't seem, like they didn't know what they were doing. That could be a witness for you in the case that things go bad with the property. Okay? Okay. That's basically the contract in sum and substance. If you have any questions about the contract, how to fill it out, or any questions about subject to transactions, please feel free to email me. My email is bill@bronchick.com. bill@bronchick.com. Good luck with your subject to deals. I hope you've learned a lot from these video lessons and that you go and do some great deals that make you a whole lot of money.